Colleagues, good afternoon, and welcome to our next session, where we will then have what looks to be a very interesting debate on a very important topic. It's called the ethical obligations of the members of the Judicial Service Commission of South Africa, where the debate will be first led by Professor Hugh of the University of Cape Town. The respondent will then be Professor Richard Devlin from Dalhousie University in Canada. We're looking forward to it. Prof. Corder, over to you. Thank you.
Hello, can everybody hear me?
We can hear you, yes.
Okay. I don't know why, thank you very much. I don't know why my camera has been disabled, but perhaps the person overall in control might like to do that, but it's fine. If you can hear me, that's the most important thing. I'm rather alarmed by Dr. Helen Cruz calling this the Corder-Devlin debate. It reminds me of another debate, Hart and Devlin. For those of us who are a little bit older and in the Anglo tradition of jurisprudence, that was about law and morals as far as I remember. This is, I suppose, so well done, Helen. This is related to law and morals because it's got to do with ethics, and the formal title is, as our chair has outlined it, the ethical obligations of the members of the JSC, Judicial Service Commission in South Africa. But perhaps a slightly broader and more informal theme of what my remarks will be the ethics of representative participation in public bodies in a constitutional democracy. The ethics of representative participation in public bodies in a constitutional democracy. Now, firstly, this starting very broadly and narrowing down, my remarks relate to the role of the judiciary in the constitution, or are premised upon the role of the judiciary in a constitutional democracy. We accept, I think, that the ideal state is for a judiciary to be both independent and impartial, but we must also accept that judges exercise public power, and thanks, Helen. Sorry, I'm not able to put on my camera. It's been disabled somehow. But anyway, so we're talking about the accountability of the judiciary for the exercise of public power. And one of the founding values of the South African Constitution in Section 1D talks about accountability, responsiveness, and openness. Our judges exercise public power as part of public governance, and therefore they must be accountable, but of course that must be balanced by a decent provision and observance, provision for and observance of independence and impartiality. Second point is that when the constitutional negotiators sat round in 1993, and I was privileged to be part of those from a technical point of view, the issue was in the full knowledge that we would be moving to a constitutional democracy and a participative constitutional democracy. How would judges be both appointed and held accountable or disciplined? And the model, which had been visited upon all Commonwealth nations from the late 1950s onwards, of a Judicial Service Commission, was adopted, but substantially revised and approached innovatively as far as its membership was concerned. In other words, it was already proposed in the interim constitution of South Africa from 1994 onwards that there be strong representation of non-governmental sectors in the JSC, i.e. the legal profession, legal academy, and the public through the 4 presidential appointees, as well, of course, as the other 2 branches of government, Parliament and the executive, given that judicial leadership would be held in the JSC by the chairing of that body by the Chief Justice and the participation as members ex officio of other judges, 2 other judges at least. The 1996 Constitution expanded that to 23 members of the JSC, the Judicial Service Commission, 10 members of Parliament, so getting up for 40% of the JSC are members of Parliament, 6 from the directly elected National Assembly and 4 from the National Council of Provinces. Importantly, of the 6 representatives of the National Assembly, 3 by constitutional diktat must be members of opposition parties. That's an important thing to note. The 4 presidential appointees were intended to be appointed with reference beyond the legal profession or government as a whole. President Mandela appointed his 4 representatives, 3 of whom were lawyers, but all of them had been participants in civil society organizations, George Bezos, Moroka SC and Entire SC, and he also appointed a trade unionist as his 4th representative. The composition or membership of the JSC changed radically with the appointment or the assumption of office of President Zuma in 2009. He summarily replaced his 4 representatives or his 4 nominees without notice to those who had served from 1994. The JSC had a relatively inexperienced chair when Chief Justice Mogoeng took over, and there was a troubled period from 2009 to 2014 in the operations of the JSC, which achieved greater stability in the period 2014 to 2019. Sadly, the last 2 years, in 2020 and this year, have been, frankly, a free-for-all. I have described the performance of the JSC in my draft paper as being patchy at best, disastrous at worst, and currently in free-fall. Patchy at best, disastrous at worst, and currently in free-fall. Part of that has to do with the absence of criteria, published criteria, formal criteria against which judges should be appointed. Listen to this statement from the JSC of April 2009, when challenged about what the criteria were according to which judges should be appointed. I quote, "There are," grammatical error, "a wide variety of factors that are taken into account by the screening committee. These include, but are not limited to, the recommendation of the judge president, the support of the candidate's professional body, the need to fulfill the constitutional mandate to ensure transformation of the bench, the particular needs of the division concerned, the candidate's age and expertise, including whether he or she has served as an acting judge in that division, and the relative strengths and merits of the various candidates in relation to each other." You'll see nothing there about commitment to the values of the Constitution. Nothing there about the independence of mind or the track record of impartiality of the candidates. It's all about external factors and relationships with constituencies. It must also be said that the whole area of judicial appointment and judicial discipline or accountability has become bedeviled over the last 5 years or so, as we live in a climate of what South African lawyers and observers know to be lawfare, the pursuit of political goals and objectives through litigation in the courts, which is a proper strategy when constitutional principles are at stake, but sadly can be misused. Secondly, place the judiciary in a very vulnerable position. And thirdly, may lead to deliberate attempts to undermine the independence and impartiality of the judiciary by forces in society who do not wish to be held accountable. On judicial discipline or accountability, there was no statutory framework in place in the Judicial Service Commission Act of 1994 until wholesale amendments which occurred in 2008, which introduced a whole new Chapter 3 to the JSC Act. There have been 3 areas of judicial accountability or alleged misconduct which have dominated, and I start with the least and end with the most dominant occurrence in the area of judicial accountability. Firstly, several judges in the Gauteng division of the High Court were pointed out as being excessively slow in delivering their judgments on the basis of justice delayed is justice denied, and corrective measures were put in place there. Secondly, the Judicial Service Commission had to deal with a judge who had been found guilty in the criminal courts of drunken driving, and eventually, after a judicial conduct tribunal had found him guilty of gross misconduct, the Judicial Service Commission in full did not agree, found him guilty of misconduct, and fined him effectively 1 year's salary. He had already by that point retired and continues to this day to draw a full judicial salary in retirement. But the judge who has occupied most attention in regard to judicial accountability is the Judge President of the Western Cape High Court, Judge John Hlophe, and he has been involved in a series of sets of allegations against him, the only one of which has reached its semi-final stage, in that he has been found guilty of gross misconduct by a judicial conduct tribunal for his intervention with justices of the Constitutional Court in relation to a pending matter involving the then Mr. Zuma, who had not become president yet. The JSC eventually sat to determine whether this finding should be referred to Parliament for the implementation of impeachment proceedings, and by a majority of 8-4, the JSC indeed referred it. Judge President Hlophe has taken this matter on review, and the matter will be heard in early February. As a result of this track record, and I'm getting to the point of ethical obligations of representatives in public life, I would argue that it is time to review the Judicial Service Commission model and its operation as we have it in this country. The model as originally conceived remains viable in my view, but I think there need to be at least the following changes made, and I will list them briefly. They're on page 8 and 9 of my draft paper. One is that all members appointed to the JSC should have to undergo mandatory training about the role expected of them. Secondly, the constituencies should be able to recall their representatives, so the bar and the attorney's profession should be able to recall their representatives and the academics if they do not live up to the expectations. Thirdly, I would recommend reducing the number of members of parliament to 6 from the current 10, 4 in the National Assembly and 2 from the National Council of Provinces, of whom at least half should be members of opposition parties. I would increase the number of judges by 2, adding 1 more judge from the SCA, the Supreme Court of Appeal, and 1 more from the Constitutional Court, elected by all the justices of each of those courts. I would institute a panel of 5 senior members of the wider legal profession, which should annually review the workings of the Judicial Service Commission and report to the Chief Justice as chair. I would insist on rigorous compliance by the JSC of its constitutional or statutory obligation to report to Parliament. I'm afraid the JSC last reported to Parliament, I think, in 2017. I would also seek every opportunity to ensure that a culture of respect, tolerance, and non-partisanship in terms of political parties becomes established in every aspect of the operations of the JSC. And this brings me to the ethical points that I want to put before you before I hand over to Richard Devlin to respond and to comment. Fully 16 members and arguably more of the 23 members of the Judicial Service Commission are there by virtue of being representative of a constituency. They are not there as a delegate to pursue a particular party political or even legal political mandate which comes from the political party to which they may belong, or a subsection of the bar or the attorney's profession to which they owe their loyalty. South African participants in this conference will know what I'm talking about. So my argument is that the ethical obligation rests upon every single member of the Judicial Service Commission as a representative to take into account multiple considerations and interests and the broader context of the importance of an independent and impartial administration of justice for all the inhabitants of South Africa, which is achieved through the superior courts and, of course, the lower courts of this country. To conclude, I would argue that the following 3 factors put this submission beyond doubt. Firstly, the legislative history of the implementation and establishment of the Judicial Service Commission, to which I've already referred. Secondly, the language used in Section 178 of the Constitution, which sets out the composition of the Judicial Service Commission. The required membership of 3 members of the opposition party, and so on, and the 4 public representatives indicate this. But above all else, and thirdly, the values which underlie the transformative character of the constitutional democracy which has been in place since 1996 indicate the ethical obligation of members of the JSC to take a non-sectarian, non-party political partisan view in the discharge of their duties. In particular, the values of the Constitution set out in Section 1 being the advancement of human dignity, equality and human rights and freedoms, non-racialism and non-sexism, the supremacy of the Constitution and the rule of law, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. Given the paramount importance of these values, buttressed and amplified throughout the 1996 text of the Constitution, It is for me inconceivable that the conduct of many of the members of the JSC, as I have described in my earlier remarks, is remotely ethical, nor does it display fidelity to the constitutional democracy which they are duty-bound to serve. The abject failure latterly by almost every member of the JSC to adhere to these values and constitutional demands raises serious questions about the ethics of the actions and omissions of such members. It is hoped that these issues in particular will benefit from the discussion generated at this conference. I thank you very much, and I hope I've kept remotely to my time. Thank you.
Professor Corder, yeah, very well done. Thank you very much. You are within your time. You've raised some very interesting points, and we're looking forward to see how they will be dealt with by Professor Devlin. I see, yeah, he is ready for us, so you're welcome to go, Professor.
Thank you very much. I'm going to try and share my screen, if that's possible. Let me see.
It was shared previously. I don't know what we did. Yeah, it's been
not sure. Oh, there we go. Try that. Is that working? Can we see the screen?
100%. Yeah, we can see that.
Okay, great. Thank you, everyone, and good afternoon. It's great to be able to join with you in Stellenbosch, even if it is virtually. In fact, if this conference had been in person, I certainly could not have made it. Rather, today I'm joining you from Halifax, Nova Scotia, which is on the east coast of Canada. This is also known as Chibuktuk in Mi'kmaq. And Mi'kmaq is the ancestral and unceded lands and waters of the Mi'kmaq people. Dalhousie Law School, my school, acknowledges that we are all treaty people, both those of us who are Indigenous and those of us who, like myself, are settlers. We also recognize that reconciliation is a core professional obligation for all lawyers and all law students. So let me start by thanking Professor Corder today for his presentation, and to also thank the organizers for inviting me to share a response. I do have to emphasize for Professor Cruz, in fact, this is not going to be a debate, and I'm sorry to disappoint her if she's hoping for a debate. Rather, what I think I want to do is try to put Professor Corder's comments in a larger context. But given that this is being recorded, for the record, I am not a relation of Patrick Devlin, and jurisprudentially and politically, I'm as far away as one could imagine from his particular worldview. So that's just for the record. I have a very different worldview. So let me start off by saying that Professor Corder's passionate commitment to South Africa as a modern, inclusive, participatory and egalitarian constitutional democracy is palpable. And because of this, his criticisms of the Judicial Service Commission are unvarnished and poignant. As an outsider, I obviously cannot speak to the intricacies of what's currently happening on the ground in South Africa. However, over the course of the last 10 years, I've been involved in two distinct projects that are very much designed to think comparatively about how various jurisdictions approach the task of designing a normatively defensible regime for the regulation of their judicials. And the first of these projects, I'm just trying to see if I can move my slideshow forward. Try this. There we go. The first of these projects was with a colleague, Adam Dodek, which we called Regulating Judges Beyond Independence and Accountability. The second and more recent project is the one I'm going to draw upon today, and it's a new book that I've come out with recently with my colleague Sheila Wildman called Disciplining Judges, Contemporary Challenges and Controversies. And it's the second book I want to draw upon today. And in this book, we invited scholars from 13 different jurisdictions to provide a critical analysis of the discipline regimes in their various countries. And the core thesis of this project is that the design, construction, and implementation of a normally defensible complaints and discipline regime for judges is an act of statecraft. And as an act of statecraft, it calls upon us to identify the core values that we might hold as a community, as a polity, and as a nation. To the extent that we all agree that a judiciary is a fundamentally crucial institution in the pursuit of a good society, it's incumbent upon us to articulate some of the core principles or values that help and guide our attempts to build a disciplinary regime. So drawing on these 13 case studies, Professor Wildman and I identify what we think are 8 key normative values, normative principles that are worthy of consideration. Now, we're not claiming that these are universal principles, but we do suggest that together they provide us with some materials by which we can assess whether there is, in fact, an effective and credible regime for the regulation of the judiciary. And I'm going to focus on the parts of Professor Corder's paper which talk mostly about the disciplinary aspects of the JSC, not so much the appointments process, although I've thought about that in other contexts. The key point I want to emphasize today is, because this is a legal ethics conference based in South Africa, is that these are not just system values, they're certainly that, but they also might help identify the define the ethical identity and the responsibilities of those who are constitutionally empowered with the privilege of serving on the JSC. Now, it's clearly a tall order for any system, any jurisdiction, and those who work within an organization like the JSC to fully achieve all of these 8 principles. In fact, our book demonstrates that every jurisdiction that we look at struggles with the design and implementation of their disciplinary regime for judges. And indeed, at times, these various values may be in tension or they may be in conflict. The challenge is to calibrate these various norms in such a way that there is genuine public confidence in the disciplinary regime for judges. And so when we apply these 8 principles to Professor Corder's account of recent dynamics in South Africa, it seems to me that there is indeed reason to be concerned. So I'm going to pick on a variety of these principles and play them out a little bit. I'm not going to go in the same order as they're on the screen, but I want to, because I think they link in different ways. First of all, when we turn to independence, in the South African context, because of the diverse makeup of the JSC, there's a genuine concern as to how arm's length this body is, and some of its members are, from the executive and legislative powers. And this immediately links to our 6th value here, which is the idea of representativeness. I think that South Africa certainly is on the right track in seeking to have a JSC that has multiple voices. A regime that, like Canada, tends to be dominated by one constituency, for example, judge, is likely to be captured by that constituency. So a balance must be struck. And so this is where the 3rd value comes in, this value of impartiality. Now, it would be naive to believe that any judicial discipline system could transcend politics. But that does not mean that we cannot strive to channel our potential impulses in ways that promote the public interest rather than sectional interests. Consequently, I would suggest that the impartiality principle reinforces Professor Corder's argument that members of the JSC are not there as partisans for a particular constituency, but rather they are representatives who serve as trustees for an independent and impartial administration of justice for all inhabitants of South Africa. In other words, their duty of loyalty, their ethical lodestar, is to the 1996 Constitution, and most especially the foundational principles outlined in Section 1 of that Constitution. Our principle of fairness has which is, as you'll see, is our 4th principle, has at least 2 dimensions. Fair procedures for judges who are being investigated, but equally importantly, fairness for those who have been the victims of judicial misconduct. It seems that in South Africa, as in some other jurisdictions just like Canada, an overemphasis on protecting judges' procedural rights has dragged out processes to such a degree that victims' rights to be treated fairly have been sacrificed. And this obviously dovetails with our 8th and final principle, efficiency. If a complaints and discipline system cannot generate timely resolutions, then public confidence will inevitably dissipate. The principle of proportionality, which you see on the screen, also builds upon the principles of fairness and efficiency. The key idea is that a disciplinary regime should have at its disposal a continuum of potential remedial options, from mild reprimands all the way through removal from office. If a system allows a judge to drag out processes long enough so that they get to retirement with the correlative pension, then it would seem that the proportionality principle has been jettisoned. Transparency is also vital, as you'll see on our screen. While it is undoubtedly true that some aspects of a complaints and discipline process may need to be confidential at the early stages to protect a judge from unfounded but damaging allegations against their integrity. As soon as there's credible evidence that a complaint is justified, then once again, public confidence requires as much openness as is reasonably possible. Clandestine processes are anathema to that. And so this circles back to the principle of accountability, which is our second principle here. It also appears to be in jeopardy, given Professor Corder's overview. Like most of the other principles, there are several dimensions to accountability. First, and most obviously, individual judges need to be held accountable for the misconduct. And it seems that this simply is not happening in South Africa, at least for some judges. Equally important is that the institutions charged with the oversight of judges, the JSC, also needs to be accountable. That accountability can be both formal, for example, through constitutional provisions, legislation, or regulations, as well as informal, through the expectations of the public. Towards the end of his talk, Professor Corder made a number of recommendations to make the JSC more accountable. I obviously do not know the South African context well enough to assess whether such recommendations would be enough to save the JSC. However, the current regime seems to be on the rocks. As an act of statecraft, it seems to be languishing. Perhaps the 8 principles I've just highlighted today might serve as normative tugboats to help to get the JSC back in the water, thereby buoying up once again public confidence in this very significant constitutional institution. They might also help to constitute the role morality of those who enjoy the constitutional privilege of serving on the South African Judicial Service Commission. Thank you very much. I'll stop sharing.
Thank you, Professor Devlin. Thank you to both of you gentlemen for what has been an absolutely thought-provoking, if not a bit of a bleak outlook, but I found it to be very realistic as well. Is there at this stage any specific questions? I have some questions, but if anyone else wants to interrupt me, they're more than welcome. Any questions from the attendees? If not, then the following. I've received this question from Professor Hugh Broderick. He says that, and maybe addressed at you, Professor Corder, but please, Professor Devlin, you're more than welcome to give your view as well. He asks the following. He says the sense may be that the role of academia in judicial appointment process is somewhat limited. Do you think that academics should play an increasingly prominent role at the JSC and on the bench? Thank you, Professor.
Thank you very much, Professor Broderick, for that question. In a formal sense, the academic legal profession is represented. There's a single representative on the JSC. It has been the same representative since 2009. That person is selected at one of the 18 monthly conferences of the Society of University Teachers of Law. I don't know, because I haven't attended those meetings, whether it has been the appointment of Professor Schlemmer has been reviewed or not, but she's a full professor at Witwatersrand University, and she's a member of the JSC. But of course, the way in which academics can participate in these debates is firstly through academic studies which are published in peer-reviewed journals, but much more so by participation in civil society, either through non-governmental organizations. And I must immediately disclose, for those who don't know, that I'm a director of a body called Freedom Under Law, which is very much in the news today in South Africa in regard to the Chlorpe application and for a review. And I'm on the executive committee of the Council for the Advancement of the South African Constitution, CASAC. So there are two non-governmental bodies which are active strongly and intimately in this whole area of the judiciary. But more so, there was an opinion piece published just on Friday by a professor from the University of Johannesburg, arguing for greater or more frequent appointment of academics directly to the bench, particularly to the Constitutional Court, or one could expand that and say to the Supreme Court of Appeal. Now, since 1994, a number of academics have been appointed directly to the bench, generally with greatly distinguished careers, judicial careers, or greatly distinguished judicial careers have followed. I can think of Justices O'Regan, Sachs, and Mohoro on the First Constitutional Court. I can think of Justice Carol Lewis on the Supreme Court of Appeal, Judge President Dennis Davis, and so on and so on. I think that there is a role, just as the pool from which judges are currently drawn has been expanded to include the attorney's profession and magistrates, and not only from the bar. And I would certainly agree that there should be more academics considered, particularly for appointment to the appellate courts. Thank you.
Thank you, Professor. Professor Devlin, would you care to maybe enlighten us as to what the situation is in your jurisdiction? Your microphone is still muted, Professor Devlin.
Okay, I think we're good now. Sorry, I apologize for that. So my view is that, in fact, for the legal profession has three legs to the stool. One is the judiciary, one is the practicing bar, and one is the academy. And that the three legs are all equally important. And so I certainly do think that academics do have a significant role to play on an organization like the JSC. I mean, we need to be careful here. I mean, we have our academic freedom, and we are in that sense somewhat similar to an independent judiciary. So I think we certainly have a role to play here. Certainly in Canada, as part of our judicial appointments process for the Supreme Court of Canada, there's a representative of the Canadian Law Deans Association who serves on that committee. Depending on the wishes of the government, the appointments process for other judges may occasionally have academics on it, but it's not part of the process. I would also add that looking at the case studies from our book, I wouldn't say that there's a pattern whereby academics certainly are involved in appointment bodies such as organizations like the JSC. I think that there certainly is a role for us to play, but again, we also need to be modest and humble in our sense of what can we actually bring to the table. So I think we bring some independence, we bring some autonomy, we bring some fresh insights and research. And so I think we actually could serve a very constructive role in this regard.
Thank you very much. I see there's a question by Dr. Helen Cruz as an academic on this matter. She wants to know in the chat, how does one deal with representatives raising conjecture and complaints in questions which have not been through a type of due process? Would you care to address that, Professor Corder?
Yeah, thank you for raising that, Helen, and thanks, Prof. Broderick. I didn't formally thank you for your question. Here is the critical role of the chair of the JSC. The Chief Justice is chair of the JSC. There are processes in place. No interviewee for public office or judicial office in public should be ambushed particularly not by what you've described as conjecture and complaints. There should be some prior notice given of the area without the specifics necessarily, but the general area in which questioning will proceed. And if that has not happened, then the Chief Justice should rule the questioner out of order. That has been a really critical area of lack of performance in the JSC in this country of late. Indeed, the Chief Justice himself sprung a question on one of the applicants for the Constitutional Court in April this year, which betrayed the most extraordinary, I think, lack of civility and respect. And as a result of that, and a challenge, a potential litigation challenge brought by CASAC, the JSC was forced to stand down and to reconduct all of those interviews again in October. So I think here we have, your question points to the role of the representatives and their ethical obligations. In the first instance, they should not be doing this, but secondly, to the role of the chair of the JSC in keeping control of the behavior of the members of the JSC.
Thank you.
I can quickly speak this in the Canadian context. So for the vast majority of our judicial appointments, there is no public process. It's all very much behind doors. And so this doesn't happen in the Canadian context. The exception to that is recently for appointments to the Supreme Court of Canada, where the person who's been chosen, and they then go through a public conversation with some representatives of Parliament and others. That process is very kit glove. It's basically a rubber stamping process. The questions put are very soft, very gentle, and they seem to be, and the process seems to be not a genuine exercise in transparency, but just a more show and tell session. So I think there are problems on both ends, too much a lack of openness as opposed to sort of uncurtailed openness, which appears to be the situation in South Africa.
Thank you very much. We have maybe time to fit in one last quick question, if there's one from anyone in the audience. If not, I'm going to maybe ask them if Professor Corder or Professor Devlin has any closing remarks, so we can close this session.
Thank you very much, Stefan. No, I'm just delighted to see Richard Devlin again. I was delighted to host him in Cape Town several years ago when we tried to distill some criteria for judicial appointments throughout the Commonwealth. And he has, through his work, the two books to which he referred, he is a really significant international leader in this area. So I'm delighted. I'm sorry that my camera couldn't work because I would have liked him to have seen me as well. Thank you so much.
I've nothing else to say. Professor Corder is much too generous, as most South Africans are. So thank you.
Thank you to the both of you, gentlemen. It's really a pity we weren't able to get your camera going. It's on our side. We tried, Professor Corder. We couldn't pick up anything that was problematic. So maybe there's an issue in the software, the hardware on your side of the camera. Be that as it may, it's not a huge concern, and we're just grateful that we were able to hear you. And thank you once again to both of you for what's been a very stimulating session. Ladies and gentlemen, we're going to now switch over to the double stream. So there is two sessions being presented. We trust that you will link into one of those sessions. You will find them on the conference program, specific links to the two sessions, which will then be facilitated by the specific, I think it's myself and Dr. Cruz. We will see you in 5 minutes' time. Thank you.